My name is Lance Rich. I'm an attorney. I practiced adoption law here in Utah for over 15 years. In my experience, I've represented both adopted parents and also birth parents in the process. I find that adoption can be a very beneficial arrangement for both sides. So in Utah, if a boy's not married to a girl, then he's not recognized as the legal parent of the child born to her, even if he's the biological father. So instead, he needs to take certain steps to assume responsibility for the child if he wants to say in what's going to happen to the child. The requirements of what he needs to do are set forth in the Utah Adoption Act. He needs to take those steps either during the pregnancy or before the mother signs her consent to the adoption following the child's birth. A girl doesn't have to inform a boy that she's pregnant in Utah because Utah law recognizes a girl's right to privacy during the pregnancy. If a boy has sex with a girl, he's legally presumed to know that the girl could get pregnant. She could deliver the child and place the child for adoption. In making this law, the legislature was concerned that a girl might be scared to tell other people about the pregnancy. The legislature didn't want the girl to end her pregnancy for that reason alone, but rather wanted to encourage her to consider options for giving a future to the unborn child while protecting her privacy. Well, he's required to do 4 things. First, he needs to file a paternity action with the court. He can find those documents off the court website, fill them out, and file them, or he can retain an attorney to do that for him. There's a court filing fee that's currently $360 that he would pay when he files his petition unless the court gives him permission to file it without paying it. And then the second thing that he needs to do is he needs to file a sworn affidavit in that same action stating that he's willing to take care of the child, explaining how he's going to take care of the child, and also agreeing to entry of a court order that would require him to pay child support and his fair share of the expenses relating to the pregnancy and the child's birth. The third thing that he needs to do is that he needs to register notice with the Utah Department of Health of that paternity action that he's filed. And the fourth thing is that he needs to have offered and paid his fair share of the birth mother's pregnancy-related expenses, as well as those expenses in connection with the child's birth, unless he's prevented from doing so. He has to do all those 4 things, and if he doesn't, then he's considered to have waived his rights to the child. Again, his time for doing those things are, his deadline, he has 1 full business day after the child is born to be able to take those actions, or before the birth mother formally signs her consent to the adoption. So relinquishment is the legal process of placing one's child for adoption. A parent signs a relinquishment document wherein they waive all their parental rights so that someone else can raise the child. That document, relinquishment document, should be prepared by an attorney or provided by an agency to make sure it complies with the law. And the parent who signs the document will want to follow the instructions of the attorney or the agency to make sure that they're properly signing it. She needs to wait at least 24 hours after the child is born to be able to sign her relinquishment. Boy can sign at any time, even during the pregnancy. Once a parent signs a relinquishment document, it's considered irrevocable, meaning that they can't change their mind. So that's why it's important that they really think through the process, get the counseling that they need, make sure that that's what they want to do before they sign the paperwork. One thing that's important to know about your legal rights in the adoption process is that you can always seek out legal counsel and talk to an attorney about what your rights are. What I've explained thus far, laws are different from state to state, and laws change too. And so it's always a good idea to talk to an attorney to find out what your rights are in the process. Now, if you're an expectant mother or a boy who may be a father of a child, and you're interested in doing an adoption, you should understand that most often the legal costs are going to be taken care of by the agency or the adopted parents. So most likely it's not going to cost you anything out of pocket to get the legal advice that you need. And that goes as well if you want to talk to a counselor, adoption professional, just to explore your options. Again, the agency, they're going to cover the costs of doing that. So sometimes people are worried about, well, is this going to cost me anything? And the answer is no, it's not going to cost you anything. In fact, in most cases, pursuing an adoption plan can help you with a lot of the expenses of the pregnancy that you might otherwise have to pay if you didn't place the child for adoption.